Welcome to the first installment of Gowling WLG's M&A webinar series, M&A in Uncertain Times. Today, our panel will discuss how the disruptive effect of COVID-19 is impacting M&A transactions in Canada at different points in the deal lifecycle. An article covering some of these items that we will discuss today is also posted on our website, and we've already set up 2 further webinars scheduled for the series, which I'll highlight at the end of today's program. But before we start, there's a couple of housekeeping points we'd like to cover. First of all, to view this presentation and all the speakers, please click on the speaker view in the upper right-hand corner of your screen. For questions throughout the session, please use the Q&A button at the bottom of your screen to ask a question. We'll try our best to answer some of your questions at the end of the session, and you should feel free to reach out to anybody on the team if you have questions afterwards as well. The presentation is being recorded and it will be posted on our website in a couple of days. This program counts for 1 hour of CPD. For example, in the case of Ontario, 1 hour of substantive credits towards CPD requirements of the Law Society of Ontario. Also, here's our legal disclaimer. Today's session will be a high-level overview. For specific advice, please contact your legal counsel often. And as you know, the situation is extremely fluid and changing daily. And now to our panel. Participating in today's session from west to east are Cindy Laval, Ian Palm, Farhan Amar-Khattab, Tiffany Bianchi, and I'm Kathleen Ritchie, and I'll be moderating the discussion today. Turning to our agenda, our plan is to cover deals at various stages in the deal lifecycle. First, those that were at the LOI stage or letter of intent stage when COVID-19 really started to impact transactions in Canada back in early March. Second, those that are at an interim stage where the definitive acquisition agreement was signed up, but the deal hasn't closed yet. And third, those deals that have closed, but where there might be a post-closing impact from COVID-19. I'm going to ask our panel members to provide their insights on a number of topics, both from the buyers and the sellers' perspectives, and to offer some practical steps that parties can take now to address these challenges arising as a result of COVID-19. So let's turn to the LOI stage. And let's talk about some transactions that were in their infancy at the time that this all started. Our first topic is negotiating an exclusivity period for due diligence and for negotiating a definitive acquisition agreement. Let's turn to Cindy. So what are your thoughts from the perspective of the seller or the target?
Sure. Thanks, Kathleen, and good morning, everybody. Good morning, because I'm in the West. Parties in the letter of intent stage will likely now be considering how disruptions caused by COVID-19 affect their previously negotiated initial exclusivity period for completion of diligence and finalization of definitive acquisition agreements. Sellers will generally want to push buyers to stick with the exclusivity period they negotiated in the LOI pre-COVID-19, and will want to resist requests from buyers to renegotiate this period to avoid being tied up in limbo for a period of many months rather than a few weeks, as would be common in normal circumstances. As counsel to a seller, I would recommend carefully assessing whether you should agree to extend an exclusivity period deadline in the event of delays beyond the seller's control. For example, if the buyer is unable to complete confirmatory due diligence. Sellers will want to push buyers to move as quickly as possible to sign up definitive binding agreements to remove the seller's deal risk. However, sellers will need to tread very carefully in this area to ensure that failure to provide additional time does not inadvertently allow a buyer to walk from a deal. For example, if a buyer has a due diligence out, failure to extend an exclusivity period to allow a buyer to complete its due diligence may force the buyer to terminate the transaction in reliance on the due diligence condition. Tiffany, can you provide some color on the perspective of the buyer?
Yes, thanks, Cindy, and hi, everyone. I think as a result of the pandemic, buyers are recognizing that the economic landscape and overall valuation of the target can look entirely different within a very short period of time, certainly from what they had originally intended to purchase. So buyers will want to negotiate an extension to the exclusivity period by a few weeks or really as long as possible to allow for potentially significant delays in completing their due diligence, which we'll talk about in just a moment, and further negotiating the purchase agreement, all stemming from the social and economic impacts of COVID-19.
Thanks, Tiffany. So now moving on to due diligence issues, obviously it's not business as usual. And while much of the due diligence could be done and is already done electronically through data rooms, Tiffany, can you comment on how COVID-19 is impacting due diligence on buyers today?
Sure, absolutely, Kathleen. Although restrictions on non-essential business activities will undoubtedly result in unexpected delays during the due diligence phase of the transaction, as you mentioned, Kathleen, the expansion of virtual data room and video conferencing usage will at least offer some interim solutions to the buyer. That said, either on the ground or in-person site visits for physical inspections of facilities or assets for the time being will not be able to take place given continuing social distancing measures. Also, the buyers need to recognize that its due diligence searches from government agencies may take longer to receive or may not be received at all due to office closures or staffing shortages. What we're going to see is that buyer standard legal diligence checklist will likely be supplemented by a COVID-19 specific set of questions. The questions, of course, should be tailored to the particular target and its industry. However, buyers will likely shift focus to certain areas in conducting their due diligence to identify and understand the potential impacts of COVID-19 on the target business. So we may see a more concentrated focus on the target's personnel and its ability to function remotely, supply chains and possible alternative suppliers, and resulting implications on inventory and operations, and material contracts to identify provisions that may be adversely affected by COVID-19, including any force majeure clauses. I think that despite the buyer moving forward with its due diligence exercise during this time, as a result of potential incompleteness of buyers' due diligence investigations, we're also likely to see buyers requesting in the acquisition agreement broader representations and warranties with fewer qualifiers from sellers, specific indemnification obligations, and likely the inclusion of the completion of a confirmatory due diligence as a condition precedent to closing. Faran will now speak to due diligence issues from the seller's perspective, and I suspect he will have a very different take on the scope of buyer's diligence.
Thanks, Tiffany. I mean, I agree there's a lot of difficulties these days for, sellers or targets in terms of providing buyers with the right level of due diligence. To a degree, the advent of online data rooms for the last few years will make the process easier because we're all already used to, starting due diligence, getting access to a data room. Some of the items that will make life a little difficult for vendors in this atmosphere is certain contracts that may only be available in hard copy form, maybe at an office where there's nobody physically available to, go to the filing cabinets, pull the contracts and scan them to a data room. In certain types of businesses, there are contracts that are very sensitive, or certain types of government contracts, that may be labeled as secret or top secret that can only be provided in hard copy form. So those types of reviews certainly will not be occurring at this time. The other item that sellers need to be careful of is we typically would give buyer's counsel access to a data room and give them print access on the assumption that they're printing these documents in their secure work premises where people can't get access to those papers, whereas people are now working remotely from all over the place. So you really have to be careful about where people may be printing your sensitive documents. We're hearing a lot of people say facility tours and inspection of assets may be more difficult given the current atmosphere. Some sellers are providing video tours where buyers can look through somebody who's walking through the premises on video. Again, we would caution sellers to be very careful of who's got access to it, what type of materials may actually be shown on the video, because you don't want people inadvertently getting access to seeing what's going on in your facility, especially if you've got a skeleton crew working there at certain times.
Thanks, Faran. So our next topic is financing. From the perspective of the buyer, Ian, what challenges are you seeing?
Well, thanks a lot, Kathleen, and great to be with you folks today, and thanks for taking the time to join us. So from a financing perspective, LOIs that were struck before the pandemic arose have changed. The financing challenges have presented themselves in such a manner that parties need to reconsider a bunch of circumstances. So, the assumptions that were made at the time that the LOI was struck were probably a lot different. So we're seeing parties reconsider a bunch of things around how they intend to actually fund the acquisition. So for strategic buyers with a strong balance sheet, the challenge is probably less significant. Obviously, a buyer in that circumstance will still be looking to for ways to conserve cash at the present time. And in light of the pandemic, they're probably got other things that are more important. But perhaps they've already spent a significant amount of time on this on an acquisition, and they want to continue with the acquisition. So in those circumstances, we're seeing people look to potentially change the nature with which the purchase price is paid, perhaps negotiate with the seller to potentially pay the purchase price over a period of time to conserve cash in the near term, perhaps test valuation expectations that they had at the time to consider whether or not that it's going to still meet the internal ROI that they have for their investment. And look, generally speaking, to try and conserve cash, but still proceed with the transaction, and at the same time try to keep the faith of the seller, who is probably looking very carefully about how the transaction is going to be financed. The more challenging group of buyers to deal with in this circumstance are really the ones who are financial buyers who don't have internal cash resources to do the whole acquisition themselves. In other words, ones that are looking to either have co-investors come on board or finance the transaction with a material amount of debt. We are seeing that while banks are open for business and are very active and very engaged with parties, they are really focused on existing portfolios, and they're focused on closing existing transactions as a priority, at least in our experience. And while new investment opportunities are certainly there, we're finding that it's taking more time for them to consider it, and quite rightly so, given the nature of the circumstances. So, from a buyer's perspective, a buyer's looking to that's looking to still finance the transaction. Perhaps they can look to do a bridge financing of some sort, or perhaps do a full equity acquisition at the time, and then look to refinance afterwards when the markets settle down. Similarly, I think you need to look at, from the buyer's perspective, if you're a private equity player and you've got a bunch of LPs that are perhaps a little bit nervous about the impact of the market on your existing portfolio, you're also looking at the impact of whether drawing down capital from your LPs for a new acquisition is something that should be the focus, and whether you should be focusing on your existing portfolio for the time being, and making sure that they're fully taken care of, or frankly, ones that are challenged by the pandemic, you've properly capitalized those groups. So, I think it is consistent with what Tiffany and Cindy had said. We're finding it's taking more time, and so from a financing perspective, you need to be engaged with your seller to make sure that they understand the circumstances and what's required to meet the financing requirements. And anticipate how you're going to address them.
Thanks, Ian. From the seller's perspective, I'd say many sellers, adamantly say there should be no financing conditions to a deal, and sometimes your LOI may say that or may be silent on that. But the reality of any seller who's sitting on a non-binding LOI without a binding definitive agreement, whether you've got a financing condition or not, you need to realize the reality of the world we're living in now and work with your buyer if, recognizing that there may be certain impediments in this day and age in terms of the timing of being able for the buyer to be able to get their financing in place. And given the difficulties that buyers may have, we would not be surprised if we see a lot more vendor take-back notes being issued as either a bridge financing or as part of an overall financing to get deals done. Vendors need to realize that if they're serious about getting a deal done in certain circumstances, they may have to take on the financing risk to ensure that their deal gets done. If that's the case, at the LOI stage, when you're having that conversation, you should make sure that you are engaged with whoever the senior lender is going to be to make sure that your vendor take-back security, while it's going to be subordinated to the senior lender, mirrors the events of defaults and the reporting requirements, et cetera, so that you're kept up to date on whatever the senior lender is up to date on.
I think there's a good opportunity for smart parties to be creative about this stuff, as Farhan's described. If you've got a seller and a buyer that are prepared to collaborate, you can find ways to either do VTBs or decide that you're going to buy half the company today and decide when this pandemic's over, perhaps buy the second half later or something of that nature.
That's absolutely right, Ian. And especially for circumstances where you have some shareholders staying on involved in the business, either keeping a minority stake or where you have management, you may want to see if management wants to roll their equity over and see what the best manner is for the buyer and seller to get a deal done.
That's great, guys. Thanks. So why don't we turn to the next stage of transactions? Let's talk about deals that have been signed up but have not yet been closed. Our first topic is material adverse change provisions in acquisition agreements. And this topic actually hit the press mid-March when it was addressed by one company that was in the middle of a very large transaction. And the question came up as to whether their MAC applied in the circumstances. Cindy, what are your thoughts from the perspective of the seller or the target?
Sure. So first, just let me explain for the audience what a MAC clause is. So an acquisition agreement will typically include what's called a material adverse change or a material adverse effect, a MAC definition. So a typical MAC clause in an acquisition agreement, in an M&A transaction, is defined as any change or effect that individually or in the aggregate is material adverse to the business, operations, assets, condition of the target's business, or that could delay or impair the ability of a party to consummate the transaction. So MAC clauses really serve two purposes. Typically, they will allow a buyer to walk away from a transaction where a material adverse change in the seller's business has occurred between signing of the acquisition agreement and closing. And they also act as a qualifier to certain seller reps and warranties, which raises the standard which the buyer must prove to claim such rep and warranty was breached. But MAC clauses also generally are qualified by exceptions and exclusions that limit the application of the clause. And its negotiation of the definition and these exceptions results in an allocation of risk between the buyer and the seller. So typically a buyer is expected to accept broader industry-wide risks associated with the acquisition, while the seller accepts responsibility for business-specific risks unique to the target business and unknown to the buyer. So buyers and sellers who have already signed an acquisition agreement pre-COVID but have not yet closed their transaction will be looking very closely at their MAC provisions. As Kathleen has noted, it's already been in the news. There's been quite a bit of commentary on it. Whether or not the impact of COVID-19 can constitute a MAC will depend largely on the definition in the acquisition agreement and the facts surrounding the target company. So even if the impact on a seller of COVID-19 is materially adverse, as previously mentioned, most MAC definitions will include carve-outs for widespread events, such as general economic downturn, or even in some cases a pandemic, such that a MAC would only arise in if the target's business was disproportionately impacted by the economic downturn or the pandemic. So carve-outs from MAC clauses, which will benefit the seller in the current environment, include changes in applicable laws, industry-wide fluctuations, or risks affecting the seller's industry generally, changes in general economic or political condition, acts of God. And that's provided COVID does not have a disproportionate effect on the seller or its business as compared to similar businesses. What constitutes a disproportionate effect in the context of the COVID outbreak will be determined on a case-by-case basis once the full effects of the pandemic unravel. So Ian, what would be of interest to a buyer in connection with a MAC provision?
Well, so Cindy, thanks for outlining that, and that's a very succinct description of something that's relatively complex and in a purchase agreement is documented over many pages in a purchase agreement, and so it's something that is often hotly contested. I think from a buyer's perspective, you've highlighted a few things that are relevant, but I'll raise a couple. One is, whether or not you can determine that the circumstances that have arisen constitute what would be a MAC for the purposes of that transaction and that business. And I think that people need to remember that the courts, to the extent that they've addressed them, and it's pretty rare that they address them in Canada, but in the US, they've addressed them a little more often. But the courts set a very high standard with regards to meeting a MAC. And so it's pretty difficult to get to the standard which would constitute a material adverse change. So, a layperson coming to the table saying, hey, look, this business has had a downturn of 20% or something like that in the context of its revenue over the quarter because of this pandemic, this has got to be a MAC. While you may have that initial reaction, you need to step back and say, okay, what does the document say? Do one of the carve-outs apply, as Cindy's alluded to? So that's point number one from the purchaser's perspective that you need to keep in mind. The other point to keep in mind is, what do you want to do with that circumstance? Like, if you decide that yes, it is a MAC and you want to impress that upon the counterparty to the transaction, are you looking to get out of the transaction? Are you looking to delay closing? Are you looking to negotiate some amendment to the transaction? So there needs to be some assessment as to what your intent is and how you want to proceed. The final thing I'll add with regards to the purchaser's perspective is, if it's a debt-funded deal, you're not only dealing with a MAC in the context of your purchase agreement, you're also dealing with a MAC in the context of a credit agreement. So your lender will have hopefully a consistent MAC definition in their agreement. And you need to be careful in reviewing that to make sure that your lender doesn't come to the table and say, we think there's a MAC here. We don't have an obligation to fund on the closing the credit that we otherwise committed to. So those are things that I think are important from a buyer's perspective.
Thanks, Ian. That's great. What about interim period covenants? Cindy, can you sort of talk about those and how COVID-19 may be affecting a target?
Sure. So for those of you who don't know, acquisition agreements commonly provide that between signing and closing, the seller must conduct its business in a certain manner and not undertake certain activities without the buyer's consent. Typically, a buyer's obligation to close is conditioned on the target's compliance with these covenants. From a seller's perspective, a potentially problematic interim covenant may include a requirement to operate a business in the ordinary course, typically in accordance with past practice. Pre-COVID-19, this would be a very standard operating covenant, very market standard. However, for most sellers, this will be challenging, if not impossible, due to COVID-19, as most businesses are currently not being operated in the ordinary course of business. So similarly, sellers will also need to be thoughtful about how interim period restrictive covenants affect their flexibility to address current conditions, including throughout of the ordinary course measures to reduce costs and preserve cash. A seller subject to ordinary course of business covenant could be considered to be in breach of the covenant if it's forced to suspend any meaningful portion of its business or its employees due to the impact of COVID-19. So from a practical standpoint, sellers need to understand what they can and cannot do within the confines of their acquisition agreement, but they also need to engage and work collaboratively with buyers to get to the closing, because that's usually the end game, and need to remember that they will not necessarily be able to act unilaterally in making decisions, even though some of these may need to be made very quickly. So the parties really need to balance the desire of the buyer to maintain the target's business in the ordinary course, and the sellers need to respond rapidly to COVID-19 during the interim period. Tiffany, what will be important to a buyer with respect to the seller's interim covenants?
I think given the uncertainty associated with COVID-19, buyers might now want greater oversight during the interim period by negotiating additional information and consultation rights. So buyers will likely consider specific provisions in the types of decisions that sellers will take during the interim period to not only address the effects of the pandemic on the target business, but also to protect their future investment. These may include any decisions taken by Target to implement or comply with COVID-19 emergency measures, or to protect the Target's personnel, which would require buyer's consent. Otherwise, and as Cindy mentioned, the buyer could later assert a breach of covenant and seek indemnification, where such measures taken by seller would trigger significant additional expenses or have a substantial impact on Target's revenue. On the other hand, what we may see, and it's something that Cindy noted as well, depending on the existing relationship between the parties and the level of comfort from the buyer, we may see a more collaborative approach between the parties with respect to decisions taken by the seller, whereby either a joint committee or some type of assembly of representatives from the buyer and seller would collaborate to discuss steps to be taken to safeguard the business during the pandemic.
Thanks, Tiffany. And as one of our viewers has asked in the Q&A, why did you skip bring down of reps and warranties? The answer is I just missed it. So I'm going to turn it over. So
we recovered quickly.
Yeah, exactly.
There you go.
Thank you, Cindy. So thank you to that viewer for pointing it out. Well, I'll turn it back over to Cindy to answer the questions on reps and warranties.
Bring down. All right.
Yes.
So typically there's a period of time which can range from a couple of weeks to months between the signing of an acquisition agreement and the closing of a transaction. So due to this gap, there's typically a bring down obligation imposed on sellers where they are required to confirm as at the closing date of the transaction that the reps and warranties they gave on the date of signing of the acquisition agreement remain true at the closing. So the pandemic has, in the case of many deals, had an adverse impact on the target company's business and is leading to situations where sellers are unable to bring down or confirm the accuracy of reps and warranties that they previously provided in the acquisition agreement at closing. So COVID-19 may have now rendered some of those negotiated reps and warranties untrue. So what does this mean for sellers? Sellers will need to carefully assess their ability to meet the bring down requirement and consider the implications of a failure to meet this closing condition. As counsel to a seller, I would strongly encourage my client to engage the appropriate people within their organization to regularly monitor and review the reps and warranties in an acquisition agreement, and to identify any possible breaches and consider the implications for closing. I would also encourage a seller to engage their legal counsel in this process. Sellers should also be very cognizant of which of the reps have been qualified by a MAC provision. Has previously mentioned, sellers have more leeway if the bring down condition is qualified by a MAC standard, as this will impose a higher standard on the buyer to prove a breach of such rep. In addition, if a seller has previously provided a buyer with a disclosure letter, which is typically a document that's provided at the time of signing an acquisition that qualifies certain of the reps and warranties, the seller should re-review that disclosure letter to ensure that it still remains accurate. Most importantly, sellers should be prepared to have very frank discussions with buyers sooner rather than later, should they identify any potential issues with their previously provided reps and warranties. Ian, can you discuss bring down from the perspective of the buyer?
Yep, thank you. Thanks, Cindy. Yeah, certainly. And I think this is from a buyer's perspective, if you're looking to, either terminate a deal or renegotiate some element of a deal, or delay a closing or something of that nature, I think this is going to be an area that is going to be more fruitful in your negotiations than a MAC clause itself. We often refer to the bring down provision as really a backdoor MAC, because if you cannot satisfy the bring down requirement, that the condition that the reps and warranties be true and correct at closing as they were at signing, then it's pretty hard to meet that condition. And a deal, as Cindy's indicated, a deal like, for example, it was signed up in January. The circumstances today are materially different, likely in a number of areas. You may have laid off a bunch of employees. If it's a seller, there may be a bunch of customers that are no longer paying on time, or that are in good shape. Your supplier may not be able to deliver in the same context as they were before. There may be changes of laws, such as the essential services legislation that's in many provinces. It may have impacted your ability to meet certain requirements in your business. All of which would, so then to say those things that you said in the reps at the time of signing, to say them at closing, they may not be true. Now, the devil, of course, is in the details, and whether or not those reps to be given at closing need to be true and correct absolutely, or whether they need to be true and correct in all material respects, or true and correct qualified by a MAC. You need to look at the detail on that. And then, as I've described before, assuming you get to a conclusion that you're comfortable that this does constitute a condition that cannot be met to close, then what do you want to do with that? And I think, as Cindy's indicated, it's important for the parties to talk. There's very little value in remaining in the weeds about this right up to closing, because the circumstances in this kind of world are such that you need to collaborate. I think that really is the scope of what would be relevant for the bring down from a buyer's perspective.
And I think one point that you made is very important. When you look at the reps and warranties, there's generally two elements to them. There's the factual element that the target has to confirm, but then there's obviously the technical legal implications of much of the language that has been worked through by M&A lawyers. So it is very important to sit down with your counsel and go through it. And so in many bring down situations where I am acting for the target, we have sort of an all parties call where we walk through in detail the reps to make sure that they're accurate within the meaning of the sort of legal language that's been provided.
Yep. And I think it's also probably a good point to raise here as well. And it's not just about the lawyers, right? There's other relevant professionals that are involved, accountants, other financial advisors, and the reps as they relate to other areas of the business which aren't purely legal. You need to collaborate with those other advisors as well.
Yeah, good point.
Thanks, Cindy and Ian. Why don't we turn to the next topic, Faran, how's COVID-19 affecting regulatory court and third-party approvals?
Well, Kathleen, as you can expect, some of these approvals are taking a lot longer to obtain, as back in the so-called normal time, as we used to refer to it. That's not to say that these approvals are not being obtained. The Competition Bureau has issued some guidance that it's still reviewing things. They've issued guidance saying it's going to take a bit longer than usual, especially in terms of cases where they have to contact other interested parties and there's delays in hearing back from them. So if you are going for a competition review or Investment Canada review, you can expect the process to take a bit longer than usual. In terms of court approvals, we're hearing that interim orders can be obtained. In fact, I think, Kathleen, you obtained one via video recently. So interim orders, some courts are being flexible in terms of being able to grant interim orders for parties. Third-party approvals is an interesting area. And typically buyers and sellers will have a robust discussion about which consents are conditions to closing, which are nice to have, which are must-haves for closing. I'll give a simple description of what's happening in the market these days. Landlord consents tend to be items that need to be obtained every time, because almost every commercial lease has a consent requirement for either a change of control or an assignment of the lease. Given what you may have heard in the media, a lot of tenants are trying to get rent abatements or are behind on their rent. So if you're behind on your rent to your landlord, good luck trying to go get a consent to a change of control, unless the buyer is someone who with that same landlord is either up to date on their rent at other locations or has a stronger balance sheet than the potential target. So those are items you need to consider depending on what your negotiations with those third parties are. Another key item to consider is, given how international supply chains are these days, significant customers or suppliers may be located in a different jurisdiction. And depending on what's happening there in terms of the business atmosphere and people working remotely, whether the right people are available at the right time to provide that consent within a meaningful period of time, or whether it's something the parties decide maybe something to get post-closing, or maybe something that is then, negotiated as a separate indemnity or something else.
Great, thanks, Ron. Tiffany? Do you have any? Oh, sorry, Ian, actually. I think you were going to talk about it from the perspective of the buyer.
Sure, we'll pass it around. Tiffany can respond on it as well if she wants. So Ferran outlined a lot of points that I think are relevant in this area. I'll just augment it a little bit and say from a buyer's perspective, the things that were negotiated as consents and regulatory approvals at the time the deal was struck were probably done in the context of what Ferran has described as the normal circumstances. We're obviously now in a different world. You probably have limited control over the regulatory elements of it, but if you take a look at the third-party consents, whether they be landlords, as Ferran's described, but also customers, third-party lenders, potentially other shareholder groups. From a buyer's perspective, if this is a transaction you really want to close, you need to consider which are the important ones and which are the ones that are not quite as important. And are you prepared to close over on some of these, waive the requirement to get certain conditions, certain consents obtained, and then proceed to closing? Or if you're not, but the counterparty still wants to close, perhaps you negotiate some sort of indemnity or some sort of arrangement whereby you're going to share the risk, or someone's going to bear the risk and close over some of those conditions. From a regulatory standpoint, I think it's also important to take into account that we're all experiencing this social distancing life, and it's not just us and our direct deal team parties. It's also all those regulatory parties, and so I think patience and politeness and sort of consistent negotiation, but also and persistence, but make sure that you recognize the fact that the regulator you'd normally dealt with when he or she was in her office is probably at home, perhaps with the family, trying to manage circumstances, and they while they want to do their job, they've got to do it in the context of the same circumstances we're in. The last thing I wanted to raise was, many of the transactions we're involved with are cross-border, and so to amplify it further, if it's a U.S. party that's involved in it, you may also need to get that you may be engaged with counsel dealing with regulatory approvals in the U.S. You've got, and they're dealing with similar circumstances, same in the context of Europeans. So it's I think we need to step back and say, okay, fine. The timeline we contemplated at the time the deal was signed was X. Is it now X plus 2, X plus 3? How much more time are we going to need to get this thing realistically closed? And I think people need to be realistic about that kind of stuff.
Just one last comment there, Ian. I think you touched on it, so I should point that out for everyone listening. We have a lot of clients and regulators who haven't given much thought to the fact that while some of us have the ability to work remotely really well, others, especially a lot of government departments, are doing this for the first time. And so it's been an uphill curve, and we are fielding questions from some of our clients that work with regulatory authorities about, what is the best way to do large size file transfer, or how do you deal with certain types of filings that were never done before electronically. So it's been a learning curve for a lot of people. So patience, I think, and trying to work together is critical to getting deals done in, the situation we find ourselves in right now.
And the good news is it's getting done, right? The deals, people that want to close deals are getting it done. So it's the fact that you can't physically be in a place isn't the barrier to getting a deal done.
And the regulators are working really hard. You know, the OSC, for example, is still reviewing proxy circulars and raising any questions from a 61-101 perspective within 5 days. So they're not putting their pens down at all. We're sort of moving through this fairly quickly and almost running out of time. I think, Ron, if you want to make a quick point on termination provisions, but then we'll move on to the next stage.
Sure, happy to do that, Kathleen. From a seller's perspective, I mean, typically a seller is not given much of a choice in terms of terminating an agreement by a buyer. So we would have limited walk rights unless the consideration is, you know, shares in the buyer, in which case you may have better conditions to closing. So, I mean, all sellers generally need to take a close look at what their conditions to closing in an agreement are. And if they wish to not close, see where the business has been affected such that one of the conditions in a seller's favor may be triggered and it can walk away from the deal. But typically, if a buyer is ready to tender and waive its conditions, sellers may not have much of a choice in terms of whether they want to close or not. But I'll let one of the parties speaking for the buyer speak to what a buyer may wish to do.
Tiffany?
I would say, in addition to what the group has already mentioned with respect to MAC clauses and bring downs and any regulatory approval delays, I think from a buyer's perspective, we may also pay, or a buyer may also pay particular attention to any outside date provision that's provided for in the agreement to determine whether to terminate, since it's likely that the seller's closing conditions, as we've all previously discussed, would be significantly impaired in light of continuing business closures. I would say the other thing is that if the parties had negotiated a reverse termination fee, or what's also known as a reverse break fee, whereby an amount of money is paid by the buyer to the target after the buyer backs out of the deal, the buyer will really need to consider whether the quantification of exposure under the purchase agreement to determine whether it's worth the risk of early termination by the buyer.
Great, thanks. So why don't we, in the time that we have left, we'd like to talk about some transactions that have already closed. We do think that there are still COVID-19 impacts for those types of transactions. Our first topic in the context of a private M&A transaction is earn-out clauses or post-closing incentive payments, which are typically tied to meet post-closing milestones. Ferran, do you want to comment from the seller's perspective what your concerns are here?
Sure. From a seller's perspective, I mean, most earnouts are set out in metrics that are either financial or tied to the performance of the business and then tied to a certain period of time. That is to say, the business needs to do a certain thing by a certain amount of time in order to trigger the earnout for the vendors to get a payment. And it's typically earnouts are set up against the historical performance of the business, as in, if you did 100 million of revenue at closing, next year revenue needs to be 110 million or 120 million. And if that's achieved within a year or 18 months, a certain payout is triggered. The concern here may be that given what's going on, if it's a non-essential business, it may not be operating. Depending on the type of business it is, revenues may be down, profits may be down. So it may be more difficult for a vendor to be able to, while it's doing everything in its power to try and make the business achieve those plateaus, it may not be enough time, or business may be affected such that earnouts may not be achievable. In that case, a seller may try to go negotiate with a buyer to try and get a longer time frame, or perhaps take out the few months that business has been disrupted and focus on a different time frame. The other side of this may be businesses that closed 2 or 3 years ago, transactions that closed 2 or 3 years ago, where the earnout is now close to being payable, and certain buyers may game what's happening in the market right now, try and get the business to show a lower revenue or lower profit to avoid paying out a substantial earnout that may have been already earned. So those are items that sellers who have earnouts need to be aware of, and go back and review with their legal counsel what their agreements say. Any thoughts?
Yes. So thanks, Ferran. I think from a buyer's perspective, I think there's two elements that I think are particularly important. One is often these earnouts are set up in a manner to motivate the people that are actively involved in the business to see the business be successful. So, if it's a revenue, if it's a revenue threshold you need to meet, then you've got the team that's in there trying to make it happen. And from a buyer's perspective, these are your employees. This is your team now, or it's part of your team, and you need to make sure they remain motivated. So it may well be a bit of a windfall for you that you don't have to pay. You wouldn't otherwise have to pay this earnout because the threshold wasn't met, and maybe that's a good thing from the standpoint of a company that is otherwise challenged because of the pandemic. But you need to step back and say, okay, so that was part of the compensation for the sellers who were then, and some of whom are now my employees. What do I want to do to make sure that they're still motivated to make a success of this business going forward? And you need to think about the long term. So in that context, you need to say, okay, look, perhaps we push out the earnout date as Farhan has described for another year or another 2 years. I wouldn't push it out too far because one of the challenges with earnouts is it limits the buyer's ability to make changes in the business while the earnout is still potentially due. And so there's a bit of a delicate balance to be played in that circumstance. I think the last point I'll raise is that while we don't advocate gaming the system in any circumstance, I think one of the ways to make sure you protect against those kind of circumstances is put in certain covenants into an earnout clause so that the seller and the parties that may be entitled to the earnout are getting access to information that's necessary so that they can assess whether the earnout's been met or not, even where they may not be involved in the business.
Thanks, Ian. Farhan had mentioned VTBs, vendor take-back mortgages, earlier. Ian, do you want to comment on those promissory notes, other means of payment? And what we're seeing in the post-closing context?
Yeah, sure. So, thanks a lot, Kathleen. I just want to mention one point here, and I know we're limited on time, so I'll just raise it quickly. So, if you think about the context of transactions that have already closed, and you think about a company that you've just acquired as the buyer, and you think about let's assume it's a relatively highly levered business at the time. If its revenue is materially impacted by the pandemic, all of a sudden you've got a material amount of perhaps you don't have the same revenue to support the necessary debt on the business. If part of the consideration, the deal was a vendor take-back mortgage in favor of the sellers, chances are that VTB is significantly subordinated to senior lenders, and that the VTB such that you're going to be negotiating with your senior lenders to try and get some sort of abatement or some sort of delay in sort of a arrangement such that you can survive this period of time. You're going to have to do the same thing with your former sellers, and make sure that they're comfortable, even though they may not be secured, even though they may be subordinated and may have very little role in the actual decision making. You got to keep them happy. So whereas a VTB looked like a good idea at the time, perhaps it may not be it may put yourself in a bit of a challenge as a result of the pandemic for transactions that have already closed.
And I'll just add on to that. If the senior lender is entering into forbearance or renegotiating terms of its senior debt, as the holder of a VTB, you may want to then try and see if you can match, if you didn't do this before, try and get the same reporting and understanding on what's going on, so that your security matches the risk profile of the business now as opposed to what it had been at closing.
Yep.
Thanks, Farhan.
Yep.
Cindy, some quick thoughts on transition services agreements?
Yeah, sure. So if you're a seller and you're party to a transition service agreement where you're providing services post-closing to the buyer to help with the buyer's transition, as the new owner of the purchase business, you need to look very carefully at the wording of that agreement, particularly if there's an inability on the part of the seller to perform the services under that agreement in light of COVID-19, where you are unable to perform the obligations under a transition services agreement. You might, as a seller, be able to avail yourself of any force majeure clause in such agreement. But the ability to rely on that clause will depend on whether it was drafted in a manner that would cover public health emergencies such as COVID-19 or otherwise contains adequate catch-all provisions. Additionally, you'll want to discuss with the sellers, with the buyers, their expectations relating to performance under the transition services agreement rising as a result of the pandemic. Tiffany, do you want to speak from a buyer's perspective?
Sure, thanks, Cindy. In TSA agreements, buyers will be more focused on supply arrangements and related business continuity arrangements in light of COVID-19, particularly where material services are outsourced to third parties to ensure that the obligations under these arrangements can be met during the TSA period under current conditions. As Cindy mentioned, the buyer will also be looking at any force majeure language in the TSA to ensure that the seller will not be able to excuse its inability to perform under the TSA. And I think buyers should also consider whether the current climate could affect the timeline for any pre or post completion separation activity, and therefore the duration of the transitional services themselves. And buyers will likely, in light of this, want to extend the TSA period, especially given the uncertainty of non-essential businesses remaining closed for, at least another few months. So where it may be difficult for the seller to perform its obligations under the TSA at the moment, an extension would allow the seller's performance to resume once the non-essential business ban would be lifted.
Great, thank you, Tiffany. So last but not least, indemnification claims. Tiffany, your final thoughts as a buyer?
Sure. So from a buyer's perspective, in light of COVID-19 and its impact on businesses, buyers are likely to scrutinize the acquisition agreement to identify the seller's reps and warranties, and may make a claim for indemnification where significant losses have been identified. And we're seeing now those including, arising from supply chain disruptions or contract breaches or terminations. Also, where representation and warranty insurance, a policy has been put in place within the context of the transaction, the buyer should be looking to the policy to determine whether or not it can seek compensation under the policy. The policy language should be carefully reviewed to determine whether the buyer could rely on the policy for business interruptions or losses related to COVID-19, or whether there's exclusionary language relating to any virus or pandemic-related business losses. So depending on when the transaction has closed, for example, if it closed before the COVID-19 outbreak, there's likely no specific language included in the policy relating to COVID-19, but it's possible that an expansive exclusion relating to, sort of a general language relating to a pandemic or a virus may prevent the buyer from pursuing compensation under the policy. So definitely a proper review of the policy will be important. Cindy?
Yeah.
Sellers
Sure. So, I don't have much to add from what Tiffany said. I think the important point is that sellers should be aware that in the current environment, buyers are likely going to be looking very carefully at the reps and warranties that were provided in the acquisition agreement to see if they can have a claim for indemnification if they feel that the business that they acquired has been significantly impacted in an adverse manner given the current economic conditions. So again, just getting back to the previous point relating to agreements, bring down reps and warranties. It's very important in this environment to re-review your reps to ensure that there's no exposure as a seller for an indemnification claim on a go-forward basis.
Great, thanks, Cindy. So, so there you have it, from LOI stage to post-closing, some of the impacts that COVID-19 is having for buyers and sellers that they need to consider in the M&A context. Before we turn to questions, and we've got a few that we're going to cover, I just want to highlight our upcoming webinar in the series, M&A in Uncertain Times. You can join us same time next week on April 21st at 1 p.m. Eastern for our next webinar on how to prepare for M&A deals coming out of COVID-19. And then there's another session on April 28th where we'll cover deal dynamics post-pandemic. So we do have a couple of questions. The first one that I wanted to address was, maybe I'm going to put this to you, Ian. What are the current impacts on cross-border activity? What are we seeing there in terms of transactions?
So I think in the context of cross-border deals, I think it depends upon the jurisdiction. So, and it depends upon where in a jurisdiction. You know, most as most people in Canada doing transactions will know that very few of the deals we're involved in do not have a cross-border component to them. Whether it's a multinational you're dealing with that's headquartered outside of Canada, or it's a financing party based in the U.S. or based in Europe. Many of the deals, and I would say the majority of the deals we're actively involved in, have cross-border components to them. I think we're being particularly careful in assessing where that particular business is that's the cross-border component to the deal. So if you've got a lender that is based in Texas, you may be in a better position than a lender that's based out of New York at the particular time. If your counterparty is somewhere in the Far East, perhaps it's less of an impact. But I think if you take it down to the individual levels, the counterparties you're dealing with or the lenders you're dealing with, these are people who are actually in those places. So we are seeing impact, we're seeing delays, but frankly, we're not seeing people that are just dropping tools and saying, we'll get back to you when this is over. These are people that want to engage, and as Farhan has relayed earlier, they're finding ways to make it happen. I think one of the things I'm sort of discovering about this whole pandemic is that there are some business continuity plans in place, and to a large measure, at least as far as the stuff we do, you can engage in business going forward. So it's impacting cross-border deals, but it's not stopping deals, it's delaying them.
Yeah, and if I can chime in for a second, Kathleen, to Ian's point, it really depends on how you view cross-border. I mean, 6 or 8 weeks ago, I had a Canadian buying a Canadian business deal go on hold because of the impact of what was going on in China on the buyer's larger worldwide business, right? So, you wouldn't think of somebody in Canada buying somebody in Canada as a cross-border issue, but it had an effect. And I mean, last week we kicked off a deal where a U.S. party is coming in to buy a Canadian asset. We're heavily into due diligence and we're all systems go. So it's having some impact, but people who want to do deals are still going ahead and doing deals. Sometimes the time frame may be a little modified, but deals are still happening.
Great, thanks, Farhan. So we've got a couple more questions. If people have to drop off, that's fine. We understand. As I mentioned before, we are recording this, and it will be posted on our website. And we're happy to raise or to answer questions of people who can't stay on the line. But we will stay on for a few more minutes. Our next question is probably for Cindy. She had mentioned material changes to the company, and this viewer is wanting to get a bit of understanding of what is a material adverse change or effect. And you did cover that in your comments, but do you want to just make a quick point?
Sure. So it's usually a significant impact on your business. So it's first of all, it has to be a change. That's kind of the quick and easy answer. And then it has to be adverse and generally quite significant. So what that would look like would really depend on the particular target and their particular business, the size of the company, et cetera, because what's material and adverse to a smaller company is not going to have the same impact as a larger company. So you have to look at it on a case-by-case basis. But I do think what is really important is the carve-outs then to a MAC, because if you're struggling, if your company has had a significant material adverse change due to COVID-19, if the carve-outs include, general economic events, so it won't be a MAC if it's a change caused by general economic conditions, then a MAC hasn't occurred to your company, even if you're struggling at the current time. So the definitions and exclusion is very important, not just the actual effect that you're having at this time.
Thanks, Cindy.
So if you
Go
take
ahead,
it by,
Ian.
so I was going to say that just to take it to an example. So, all of the restaurants in Canada, and I'm sure elsewhere in the world, are currently closed, right? You can't go to a restaurant. So if you're buying a business that is a restaurant group, that restaurant group is definitely, it's impacted, but it's probably impacted in a similar way to some other restaurant group. So you have a hard time arguing that the carve-out would not apply in that circumstance. But if your restaurant group had a fire at its distribution facility, perhaps, or some significant, I don't know, you lost a major lease in respect of the certain sites you needed for that restaurant group, then it's not then it's disproportionately impacted as compared to the industry as a whole. So it's a nuanced, fact-specific analysis that needs to be done.
Great, thanks, Ian. Somebody else has asked whether a MAC is a valid reason to drop a deal at the LOI stage. And of course, usually what we see at the LOI stage is that those are non-binding agreements in the first place. But anybody want to talk about that?
Well, I think I rarely see a MAC provision in an LOI because, as Kathleen pointed out, they typically are non-binding. But if you have a letter agreement, sometimes they'll have a MAC provision. And I think at the end of the day, it really depends on, as Ian alluded to when we were talking about this. What's the goal of the buyer? If the buyer wants out of the deal because they are concerned about the future and the current environment, and it's just not the time to do the deal that they thought they wanted to do in January, then if they can rely on a MAC clause, they can terminate the LOI. But also, as Ian alluded to, it's a very high standard. So if you have a seller that wants to push on the MAC clause and claim that there wasn't a MAC, it's going to be harder, I think, for a buyer to prove that a MAC has occurred.
Thanks, Cindy. We have another question, which is, if there is a force majeure clause for either the buyer or the seller, can the company use that not to fulfill obligations? And it's an interesting question. I don't really normally see force majeure clauses in an M&A context, but certainly in contracting, generally speaking. Before I sort of put it to the panel, I will point out that we've done a number of webinars that are posted to our website on force majeure provisions, both generally speaking and in the construction context. So I'd encourage you to look on our website and find those webinars if you want detailed analysis on those particular types of provisions. But does anybody have a comment on that? Nope.
I would just say, Kathleen, echoing your point, I wouldn't typically see those in M&A agreements. Yeah. I would see them in, in a TSA, which I think we chatted about. So, I mean, you may see a seller use that as, a reason for not providing certain transitional services, but I would not generally see that as an out from closing a transaction.
And it is a topic that I think would come up more so now in the due diligence process. We look at all sorts of different provisions in a due diligence context, change of control provisions, consent provisions, things like that. But I suspect particularly in material contracts, we would be looking quite closely at those force majeure provisions nowadays. So. Yeah. Another question is whether we've fielded many inquiries from sellers in relation to amending pre-existing earnout performance targets. Are there any examples that we have where amendments have been agreed to, and were these extending performance timeframes or more wholesome target revisions? I personally haven't had to deal with that yet, but I work in the public M&A field more than private, so that's not really something that we would see in that context.
I think, Kathleen, it's early days. I mean, if you look at March 15th as the date where, a month in, and I think as the next few weeks and months progress, we'll actually see what the impact is on businesses and financials and so on, because you might have a blip of a month and then the business may change depending on what it's doing and what's happening. So I still think it's early days, but I think it's something that sellers and buyers will want to keep an eye out to see what is there, and depending on, as Ian said, what the relationship between the parties is post-closing and how involved these sellers are in the business, you may want to revisit that to preserve relationships and ensure a better continuity for the business going forward.
Yep. Like, presumably yeah, I agree with Farhan on this one. This is on the to-do list, but it's not an urgent to-do. And I think that it's focused on the very urgent items that are the key right now.
Great, thanks, Ian and Farhan. We have one last question. And I'm not sure that we're the ones who can answer this because it does sort of go into the employment law context, but how would a company's staff currently laid off at the time of sale affect a closing, assuming the sale could actually be closed on all other fronts? Anybody want to take that one?
I'll throw something out and maybe Ian will contradict me. My view, Kathleen, would be to a degree, I think it would depend on the industry whether layoffs are common in that industry or not. And if they are, and that's part of the employment workforce, you treat them as any other business where employees may or may not be laid off. So I don't think in those industries much would change. In terms of industries where it's not the norm and employment agreements don't have those temporary layoff type provisions where there's a risk of constructive dismissal being something that employees may bring up, I think you would want to either have a specific indemnity or, again, depending on whether the agreement has been signed or it's about to be signed, or if you're negotiating the agreement, I think a buyer would want to make sure that the workforce will be available to it post-closing when things go back to normal, and that it will not be left on the hook for any severance or constructive dismissal costs. And in the same point, the seller may want to make sure that it's covered its bases in terms of it's not left on the hook for any severance costs if the business is fundamentally different post-closing.
That's great. Ian, any final thoughts?
Yeah, I would just add that most purchase agreements will have detailed provisions related to employment, and Farhan's raised a few points. But I think that to answer the specific question, could you get to closing in a circumstance where there's a bunch of employees that are currently laid off? I think the simple answer is yes. I think it's going to require both sellers counsel and buyers counsel, and then their specific employment experts to sit down and say, okay, so this group of employees are currently laid off, but the expectation is when the pandemic is has passed to a point where these people can come back to work, and we don't have to close except for essential services. There's a way to make it happen. And Farhan's raised some good points about are those employees going to be available when they come back? But we've had and as Kathleen's rightly pointed out, there's a bunch of other webinars we've run specifically on employment considerations, and these are things that we're dealing with in real time, and it's changing from day to day. But my view, it can be done, and we just need to roll up our sleeves and figure it out.
That's great. Thank you, Ian. So I think we are out of time. We've appreciated the opportunity to discuss this topic with our audience today. Until next time, stay positive, stay healthy, and our very best to everyone. Thank you very much.
Thanks.
Thanks all.
Thank you.